we will discuss about the manual scavenging on the laws enacted by the government. Shortly, we can say that Indian Constitution says about Article 21 says about right to life. After passage of some time, the right to dignity of a person is inherent of right to life. The right to dignity is part and parcel of right to life. The various Supreme Court judgments from Vishaka and Safai Karamchari judgment, if you take any judgments, they defined the right to dignity is right to life. If you take largely in this country, the persons engaged in the manual scavenging work, they are belong to a particular caste. In Tamil Nadu, most of the sweepers, namely the scavengers, are belong to Arundhathir community. The casteism also play a much role to engage the people in the manual scavenging work. The government of India did three things. One is, in 1993, a legislation was enacted in the name of the employment of manual scavengers and construction of dry latrines prohibition 1993, establishment of Safai Karamchari Andolan. Third, in the year 2013, an act namely prohibition of manual scavengers and the rehabilitation 2013. These three things our government of India did it. Let us see the 1993 Act. The 1993 Act specifically brought to prohibit the manual scavenging, but in practical manner, many of the states did not implement the provisions of the Act, and also the importance of the Act and the sensitization were not reached completely to the administrations, executives, and also even I would say the judiciary. Subsequently, after 20 years, the government of India has enacted an act, namely prohibition of manual scavengers and their rehabilitation. The 2013 Act is addressing three issues, namely it gives the definitions like who is the owner, who is the scavengers, who is the government, who is the authority, who is the employee, what does it mean septic tank, what is it sewer line, etc. There is definitions are clearly defined. And the Act second part speaks about to find out the persons in the engagement of manual scavenging work. Third part is punishment, and fourth part is it speaks about rehabilitations. All the definitions defined well in the Act. For example, insanitary latrine means which are not cleaned, which are not used by water, flushing water to remove the human excreta. The Manual Scavenging 2013 Act speaks about to find the persons who are engaged in the manual scavenging work. Here, the government and the administration did not take much steps to identify the scavengers as well as to address their issues. For example, this provision says about to identify the person and issue identity card for the purpose of the rehabilitation. But this act, the administration did not take any efforts. In a particular case, two districts were identified, namely Madurai and Virudhunagar. A particular organization led by Sahaya Plamin Raj gave a representation that 257 members are engaged in this manual scavenging work, and they must be given identity card and also they must be rehabilitated. The district administration did not heed the request, so he came before the Madurai bench of Madras High Court with a prayer that the state should identify and provide identity cards as per the mandate procedure in the Act. This is what the implementation level. Subsequently, if you take the punishment and the procedural of judiciary area, the Act says if anyone contravene the provisions 5 and 6, that is, if anybody engages the manual scavenging without safety gears, etc., they are liable for punishment. If the offender if the offender guilty is proved, first term 2 years punishment and 1 lakh rupees fine. If the offender does the same offense the second term, 5 years punishment, 5 lakhs, up to 5 lakhs the court can impose. But the Act says the court should adopt summary trial procedure. In the summary trial procedure, it has to complete it 6 months, but the maximum punishment the court can give 3 months. So the Act says in the section 7 and 8 about up to 5 years the court can award punishment. But the summary trial proceedings can give only punishment up to 3 months. So this is completely contra the Act and the procedures. And even some of the definitions says about that if you have sufficient safety gears, the person may be engaged in the manual scavenging work. Therefore, what I find, the Act does not have the complete intention to rehabilitate and the manual scavenging, to rehabilitate the manual scavengers as well as the abolition of the manual scavenging work. The government has allocated funds for various activities, huge amount, but to address these issues, the government has not paid much attention for the rehabilitations, etc. If you take 2014 judgments, for example, in 2014, the Safai Karamchari versus Union of India judgment speaks about right to dignity, right to life, and the rehabilitation of the manual scavengers. The particular directions was issued that the government has failed from 1993 after enacting the Act to find out the persons and rehabilitate them. Therefore, any person died in the engagement of scavenging work, their family have to be given 10 lakhs rupees compensation, the relief amount, as well as that the government has to find out and provide it. The government did not take much efforts to find the scavengers, the deceased family, and also if they send any representation, the lethargic attitude of the government officials to pay the compensation. These judgments not only for the compensation, and also the judgments particularly said about the prohibit the severe line death and prohibition of manual scavenging work. Furthermore, it also directed the government authorities to provide loans and allocation of plots for the promotion of the well-being of the scavengers. But the government did not address the problems as well as the issues. In a particular case, a lady came before the Madras High Court Madurai bench, a old lady, namely Valayaka. Her son died in the cleaning of a particular septic tank in a private house. Though she submitted with all the evidences like first information report, which says about the deceased son died due to asphyxia while cleaning septic tank. Similarly, the lady also produced the death certificate, but the district collector as well as the principal secretary failed to provide compensation. Thereafter, she was forced to file a writ petition before the Madurai bench of Madras High Court. The High Court, after hearing the case, issued direction to pay the compensation. Instead of paying the compensation, in the light of Safai Karamchari judgment 2014, the government went to appeal before the division bench. The division bench also dismissed the writ petition, the writ appeal filed by the government, and directed to pay the compensation. Not only that, subsequently the government of Tamil Nadu went for a review petition and also for clarification whether the government is liable to pay the compensation if a person died in a private house, private place. Then Supreme Court said, you identify all the persons, the scavengers who are died in the septic tank and during the scavenging work, you have to pay the compensation. Thereafter only the compensation was paid to this lady. The attitude of the officials and also the sensitization of the act is lacking. The officials should find out the scavengers, the officials should identify it, the official should rehabilitate them, the officials should provide good education to the children, and the judiciary also seriously take the attitude of the government officials and grant relief. It is necessary at this